Hello everybody. Today we have with us Justice Pratibha M Singh, who's a sitting judge of the Delhi High Court. And she's here to talk about a very special occasion, her debut as an author. Justice Singh has recently authored a book on patent law, and she is the first sitting judge of any high court to do so. Many congratulations to you, ma'am.
Thank you, Badra.
So first as a lawyer, then a judge, and now author. What was the need to write a book?
I must say that I used to, as a child, write some poetry. I have written some articles and, publications on IPR as well. For example, in the Technology Law Journal published by the National Law School, I wrote on copyright. And the WIPO asked me to co-author a patent guide for judges, which I've done with other judges. But this particular book has been a passion in the sense that there was no book on patent law in India at all. And IP being a very kind of nascent kind of subject in which like maybe my generation or maybe one generation above me have practiced, there were no good IP books. And I always felt the need, especially for a patent book. Whenever we litigated in the courts, we would only cite foreign commentaries, some of which you can actually see in my library.
Okay.
So we never had an Indian patent book, and that's why in 2015, when Thomson Reuters approached me for writing a student book on IP, I said, no, I want to write a commentary on patents.
Okay, so as you just mentioned, passion. You've been very passionate about patent and IPR. And I think that passion got reflected in the most significant judgment authored by the Supreme Court in the Notis case. Can you just very briefly tell us about that case and how it triggered that passion further, and maybe that also culminated in the writing of this book?
The Notis decision of the Supreme Court was a watershed moment in my life. The minute that decision happened, I felt that I need to move on in life, and that's how I then became a senior, and then I agreed to become a judge as well. So the Notis case is a very significant decision in India because it dealt with a very important provision of our law, which said that once you have a substance or a pharmaceutical product which is patented, you cannot make modifications of that and get further patents. It is called the concept of evergreening. And India stopped evergreening, and Notis recognized that you cannot do evergreening. This has a very major impact on the pharmaceutical industry in India because after 20 years, all the products which are patented fall into public domain, and it's made available much cheaper than obviously the innovator drug.
So how did that case actually give you a lot of satisfaction as a lawyer in the field of IPR?
I remember a leading channel interviewing me when the Notis decision happened, and I remember telling them, no one knew about patents, but the Notis case brought patents to the drawing room of every home. Even housewives and friends who were not involved in law would ask me about how did this happen, how important it is, and everyone understood that it was a very important decision.
So I'm coming to a leading question. Why do you think it is important for the citizens today to understand about patent law?
I think there are broadly three reasons. The first reason is that in the field of medical products, medicines, devices, biotechnology, etc., we need to understand patents because our requirements in our country are very different. Diseases which Indians have or Indians get, a lot of times foreign countries and developed countries don't have those diseases. So we need our own innovation in the field of pharma and in devices. And so it is important that Indians need to innovate, Indian inventors need to innovate, Indian companies need to innovate. Apart from that, there are two more reasons. The first reason is that in India, we have a huge culture of startups and youngsters investing their time in newer and newer technologies, whether it's in the form of apps, whether it's in the form of business models, whether it's in the form of electrical and digital technologies, or in the form of AI or anything. Nowadays, every home has engineers And whatever they are innovating, we need to encourage their innovation.
So, is that the reason that why India should today have a robust intellectual property right regime?
I think so, and I think there is no looking back since the time. I mean, you remember in 2015, the IP think tank was constituted when we drafted India's IPR policy, and I was a part of that. And since then, there has been a huge investment in terms of human capital into innovation. And if you don't invest in intellectual property law, the commercialization of that innovation won't happen. For economic growth, you need intellectual property.
Yeah, that's right. So, how do you see, the trajectory of the patent ecosystem in India, from what it was to what it is today, and how has it really developed or contributed in the global development?
So, I missed out the third reason which I was about to give you. The trajectory of patents is going to be very important, especially because the third reason I feel that patents are important is because of climate change. The whole world is discussing about climate change, and a large part of the green technologies and environment friendly technologies are patented. So we need to ensure that the patents in this area become commercialable and technology transfers take place, and patents do not act as an impediment in ensuring that the technology moves and it becomes accessible to everyone. So now coming to the trajectory of patents, I can tell you one thing, that earlier times, in the early 2000s or even till 2010, 80% of the patents were by foreigners in India, which were being registered. But as of last month, the statistics that have been revealed are almost 55% of patents are owned by Indians.
Okay.
And Indians have actually changed the majority here.
Right.
So now you see that if it's 55% Indians who are innovating, Indian entities, Indian inventors who are innovating, then that means that India has now built up an ecosystem supporting patents. And if you don't then allow patenting, then there won't be any economic growth. And the trajectory of patents is very clear. It is going to increase Indian innovation, and that will also lead to a large influx of patent related litigation across the country. So I think the context of this book is also because I think the subject needs to be explained from the Indian context.
Okay. And how has it contributed to the global development?
I look at global development not just economically, but from the human point of view. If you look at the entire pandemic, COVID pandemic, it is impossible for someone to think that in 7, 8, 9 months vaccines could have been invented. The vaccines could be invented because of the entire research and patent ecosystem in the world. And secondly, India was self-sustained on vaccines. We also exported vaccines because of the strength of our pharmaceutical industry. If we did not locally manufacture vaccines, can you imagine what would have happened to our country?
Right.
Because we would not have been able to even get affordable vaccines for our country.
Right.
We therefore not only vaccinated more than 100 crore people, but we also exported vaccines. And the context of patents is because these companies who are all innovating in some form or the other, whether in the processes, just because we got the vaccine from somewhere abroad, or I think one of the Indian companies, Bharat, in fact actually innovated the vaccine itself, and those companies are all sustaining because of their patent system, where they are able to generate more and more innovation, commercialize their innovation, and then in times of emergencies they are able to support the country. Just imagine if there was no these companies, I can't remember the names, Bharat Biotech and the other company in the Poonawala's company. If these two companies weren't there, how would we have done it? Or the other companies which all make vaccines. These are companies which had strength in making vaccines. That's why they were able to do it.
Right. But ma'am, there is a very, a certain amount of concern is generated because India is a growing market. And of course, it has space for foreign inventions as well. But concerns are raised about, the indigenous innovations. So do you think our patent law is, strong enough to take care of these complex situations?
Oh yes, I must tell you that some of the initiatives like giving expedited examination for women inventors.
Okay.
expedited examination for startups. So if a normal company gets a patent in like 4 to 5 years, a startup can get it in 2 years.
Okay.
Women, and the fees which is charged for them is lower. So these are initiatives which are really helping in boosting the ecosystem for patents. And I think we do need patent law. If not for that, you can have law, you can have these technologies as a trade secret, in which case they will never come out.
Okay. Okay. Yeah.
So that can be very dangerous for any ecosystem.
Okay.
Because if the purpose of patent law is that a scientist discloses what he has invented, and in turn he gets the 20-year monopoly.
Yeah.
Imagine if there is a formula which is just held as a trade secret for 200 years.
Then it will never,
It will never come out. So patent law is also about bringing more and more innovation into public domain. So that we don't reinvent the wheel every time.
Right. Right.
That's the purpose.
Let's come to the existing infrastructure. Do you think India needs to invest more in it, to kind of considering that the growth which we are witnessing in our innovation industry?
I think in the last 1 year, we've granted 1 lakh patents.
Yeah.
And that's a huge number. And if we go in this manner, I won't be surprised if India becomes among the top 3 countries in the world granting patents, which is huge, because the fact that so many patents are granted means the number of patents which are being enforced and adjudicated will also be high.
Yeah.
I can speak from my experience of the Delhi High Court that in my initial years of practice, I would only see maybe 1 or 2 cases in a whole year. But now the most contested cases in the High Court are patent cases. We have about 100 to 150 cases in a year.
So that
on patents.
That actually shows that we really need to invest more in the ecosystem.
In judicial infrastructure, absolutely. We need to train more and more judges on patents. We need to have better scientific people advising and helping the court in adjudicating these cases.
Okay.
That's why the parliamentary committee has in fact recommended that all high courts in the country need to have IP divisions.
Okay, a separate IP divisions.
Yes.
Okay, my final question to you is, it actually emerges from chapter 20, in which you have actually urged, the inventors not to just look at the monetary gain of inventions, but also to think of, of the humankind, for the betterment of the humankind. So could you just elaborate a little bit more on this, and why did you feel the need to, have this thing in your book? My own experience in patent law shows that patents are always considered like a rich man's luxury. But now it is no longer a rich man's luxury. It is the necessity for the growth of any economy. Therefore, while we grant patents, patentees have to remember that at the end of the day, every right which is being given is for betterment of society. I remember I was cross-examining one inventor in one pharmaceutical case, and I asked the inventor, what makes the inventor feel better? When the invention is monopolized and is given to a few patients, or when it is made spread out across patients. So the inventor's reply was, whatever the companies may say, the inventor always felt that the invention is meant for society and for patients and for humankind. And therefore, I feel patents should not just be considered as a rich man's luxury. Patents should be given for all people who innovate, including small enterprises, medium enterprises, big companies, individual inventors. And all these inventions should be ultimately for the betterment of human beings. Okay, so one last question, and the reason I'm asking you is because it's really talked about artificial intelligence innovations. What is your view on that?
I don't think currently the law is permitting artificial intelligence innovations. At the moment, I feel artificial intelligence is just like a computer software or a tool.
Yeah.
If a human being invents something using artificial intelligence, I think the human being can be given a patent. But if an artificial intelligence software by itself innovates something, in the current system of the law, we do not grant a patent. But this can be changed depending upon what technology does. And
but do you see the debate becoming more contentious around this?
It would become very, very contentious, because at the end of every journey, I feel intellectual property is for rewarding the human intellect.
Yeah.
It is not for machine intellect.
Yeah.
So if it's for human intellect, then I think intellectual property law should not be expanded to include artificial intelligence. But that's the view I have as of today. So I don't know, maybe if there's a breakthrough invention
Yeah.
by an artificial intelligence which maybe says, suppose it's a cure for diabetes.
Okay. Yeah, then yes, that's right.
I don't know, maybe the world will decide that no, this is so breakthrough that it has to be given even to a human, even to a
Artificial,
computer.
well,
So,
well, thank you
that's
so
what I
much,
feel.
Justice Singh,
Thank
for
you.
joining us, sharing your insights into your journey as a patent lawyer, then as a judge, and also the growth of patent law in India and its future. Thank you so much.
Thank you, Bhadra.
Thank you so much. Thanks.
Thank you very much.